Okay, Chairwoman Warren, this is Representative Patton. I think we've got most everybody. Are you ready on your end? You in the room?
Yes, yes.
Okay, well, I would just like to welcome everybody. I thank you all for making this time available on your calendar. I'm appreciative that we have most everybody. I wasn't completely sure who all we've had, and I know some of you had to move things around, so I appreciate that. As you know, this is a bill that we started back in 20, I guess it was it 2019? The bill passed, and we had a meeting back then. And we thought we would meet again the following summer into the fall and wrap up our work. And unfortunately, COVID happened, and we had some KEMA special meetings on KEMA in the fall, and we just didn't meet those deadlines. And so this session, we gave ourselves another year. And so that's where we're at this point in time. We have some new deadlines to work under. And again, I think we can get there. As we walked out of that meeting that we had back in September of 2019, there were a couple of you that had expressed some interest of getting together to try to come up with something to present to the group, and that actually happened. Unfortunately, we never had the chance to present it out, so we're going to get to that today. So hopefully we can move forward and meet these deadlines. Chairwoman Warren, anything you want to add at this point?
I want to thank everyone for joining us here today. It was an issue that did come through Senate Judiciary Committee to give the task force additional time to get their report done, because the work of the task force was interrupted by the pandemic last year. So appreciate everyone's continued effort on these issues, and I look forward to hearing about them, since I am new to the task force, but very interested in the work that's being done. So thank you.
Very good. Senator Haley, I didn't give you any advance notice that I may want you to say anything, but is there anything you want to add before we get started? I appreciate the work you've done on this and kind of prodding us to keep this process moving forward.
Well, thank you. I'm humbled by that. Thank you, Chair Patton, and thank you for your leadership from the previous task force meetings in 2019. I'd like to thank you and Senator Warren for having the meeting, and I am new to this committee. I've been interested in this topic. I think the new and the novel approaches to resolving code cases could put Kansas at the forefront when we apply DNA technology, based on some examples we've seen and others that this task force will come to. And I'm glad to be made now as the ranking member, which I wasn't in 2019. But to be a part of the task force. And again, to thank you, Chairman Patton, for your previous leadership, and both you and Co-Chair Warren for moving us forward to meet our deadlines.
Very good. You're very welcome. This is important work. Committee, as most of you, whether you were on the committee or not, you were in the room when we had the meeting in September 2019. But just to refresh your memory, we had presentations by Senator Haley and Tricia Bushnell with the Midwest Innocence Project. I think I saw Tricia in my side here somewhere. She's online. And then Rachel White from the KBI did a presentation on CODIS and current practices on CODIS hit dissemination. So that was kind of where we left, and we had some preliminary discussions, but that was about it at that time. I had Natalie from Research Today send out a couple documents to you, so hopefully you received those in your email. One I just put together this morning. I copied it straight out of the bill, the conference committee report we passed this year. I just labeled it a little bit different. So you see the task force charge, what the legislature has asked us to do, those five items listed there. And then you'll see our timeline down below. So again, we're on relatively short timeline once again. I think the primary goal is to have that report ready by December 1st that we can submit to the KBI, the governor, the speaker, and the Senate, that we can make some recommendations and hopefully make some progress in this area. The bulk of what I wanted to do today was to have a presentation on the recommendations that small group worked on last summer. And you also have that's been emailed to you. Again, maybe this may need updated, some things may be changed, but this is what they've come up with for last year, kind of a starting point for us as a task force to have further discussions. Justin Edwards, who is on a WebEx here with us, kind of took the lead there and helped put this report together and submitted it back to me. And Justin's on here, and he's going to walk us through this. I don't know if he's going to involve anyone else in his presentation, but out there somewhere. There we go. Justin, I'm going to just turn it over to you.
Thank you, Mr. Chairman. And I do want to also involve Robert Jacobs. I know he's on from the KBI, and he and I had a brief conversation yesterday, and he was actually very instrumental in our conversations last year when we put together these proposals and the memo that you should all have in your materials. And first of all, I want to say when we came into this, we kind of came in with a lot of different goals and a lot of different ideas about what might be and what actually existed. I can tell you from my experience, I actually got an eye-opening experience because I learned about the availability of information that had not yet made its way to prosecutors across the state, and I believe was actually making its way at the time and now has been rolled out to law enforcement, and that is the LIMS program, LIMS, the Laboratory Information Management System used by the Kansas Bureau of Investigation. So when we got together and Chairman Patton put us in contact, myself and Darren DeVinny, the two prosecutors on the task force, with Professor Craig from KU and Tricia Bushnell from ACLU. And then we also had Jeff Hahn as kind of our technical supervisor, technical advisor, and then Robert Jacobs. And I think what we've found through this is there was a lot of misunderstanding about, or maybe not misunderstanding, but lack of information, lack of knowledge about what actually exists already. So what we found is the KBI, when let's say a case exists and there's a sample put into CODIS or put into the database to be run against CODIS, that CODIS report may be years in the delay in finding a hit based on new information that's added to the CODIS database every day. So what happens then when a CODIS hit is generated? And what we've found, and what some of us knew, but we've found, is that it goes through the KBI, a hit report is generated, and then a report is generated from them to the submitting agency, that being law enforcement or one of the regional forensic science centers in Johnson or Sedgwick County. That report then is to go to law enforcement and then to the prosecutor. What we found is there are actually ways to shortcut that in a way, and that is through the LIMS process. The prosecutors actually have access to LIMS. That's something I didn't know, and I don't know that Darren, I won't speak for him, but I don't know that most of us knew that prior to our involvement in this process. So as we talked about it, what we've really came to the realization is that once we educate our prosecutors and educate our law enforcement about the availability of these hits and these reports, that hopefully the expectation would be these reports are not just sitting in a cabinet somewhere and not being turned over to the defense and notifying them as required. One of the significant considerations we had to deal with and will be dealing with is federal law and the restrictions they place on who can have access to CODIS and CODIS reports. And I know you'll recall the KBI presentation from 2 years ago now, but 34 USC 12592B3 actually limits who can get access to reports generated from CODIS. And so it initially has to go through one of the labs, and then it has to be disseminated actually through our law enforcement to our prosecutor, and then our prosecutor pursuant to law, pursuant to discovery rules. So our proposal is this. The KBI has agreed and has offered to do training, and they've already undergone some training for law enforcement, and they're going to make it part of the mandatory training for law enforcement as they go through training on discovery, on DNA, and other CODIS issues. But they've also been invited now to speak at KCDAA, the Kansas County and District Attorneys Association. And I know just yesterday, Robert has had communication with the chair of the CLE committee, and they've been invited to actually present next month at the KCDAA conference to all of the prosecutors statewide to educate them on the availability of the LIMS process, the availability of these reports, so that there should be no excuse for not having these generated to the appropriate people and then provided in discovery. And that's an ethical obligation that we as prosecutors have to follow, and that is to provide discovery in a timely manner. And that's going to be the second part of that training, that prosecutors would be expected to immediately turn that over pursuant to our rules of discovery. So, Robert, am I forgetting something?
No, Justin, I think you did a great idea or job summarizing not only the recommendations we came up with last fall and as well as our current conversations regarding the ks.gov training, which it does appear we're going to do in October.
And one last thought I had, I put it in the memo, but one of the other educational components that we're going to have, and I think, I won't speak for Robert or the KBI, but an educational component for defense counsel so that they are aware that these are options and that they can make a specific request of their prosecutor to look for specific case numbers and specific information in the LIMS database. Use that LIMS portal and see and specifically search for any new reports that have come on behalf of their client. They don't have to, they shouldn't have to, because the discovery obligation is one that rests with the prosecutor and doesn't require any action by the defense. But if there was ever any concern that they were not being provided, an attorney simply has to ask the prosecutor to specifically look in the LIMS portal, and that's something they can do.
Perfect. Or Tricia, Darren, anything you guys would like to add?
The one thing I'll definitely join with Justin on is the lack of information that was readily available to any number of us that were at that meeting 2 years ago with regard to the matriculation of how that information comes through the system and then ultimately how it's disseminated into an individual court case. Like Justin said, education is a huge component that I think that we need to be developing, not just for prosecutors, not just for law enforcement, but it's also for defense counsel. It's for those individual defendants, and it's for the betterment of even KBI and KLETC and some of these other agencies and entities that deal with these matters. I don't know that they were fully aware of how ill-educated prosecutors and law enforcement were with regard to the dissemination of this information. So it was a good opportunity some time ago when we created these recommendations to everybody join together and say we all need to learn a lot more and share a lot more with regard to this information. And I believe that the recommendations, I fully support these recommendations being considered here today and potentially adopted. But it was an enlightening experience, and I'll again echo, I don't mean to repeat everything that Justin said. He did a very thorough job here, but on behalf of KCDAA, the fact that we're going to go ahead and address that in October at our fall conference, despite the recommendations being something that would be quadrennial, prosecutors have an interest in making sure that we're having access to this information and disseminating it because of the ethical obligations that are tantamount to the job. So I appreciated being part of the workforce, but also being part of this greater task force and making these recommendations, because they seem to be very fair, even-handed, and actually quite comprehensive at this stage with regard to the dissemination of this information.
This is Alice Craig. If I can, I helped draft these, and if I can make a few comments as well. I think when we were doing this, we really were sort of focusing on what our first steps were. And I think this is a first step. Rereading this now, what, year and a half later, a year later, I think there are some parts that maybe we need to clarify or strengthen a little bit. And I think that goes to potentially the access for defense counsel and the education for defense counsel. These are primarily focused on prosecutors, which, you know, in regards to CODIS and the LIMS system, that's probably the most important place for education, just because they are the ones with access. But I do think we need to strengthen maybe the sections that allow for, I'm thinking of the two separate situations. There's one situation where there may be a new hit in the LIMS system on somebody who's unrepresented. And so the prosecutors would need to go back and find counsel. We need to think about that situation, and we're assuming that they would notify the last counsel on record. The second situation I can think about is one, if the Midwest Innocence Project or our clinic has a case where we need to request a prosecutor to specifically go into the LIMS system and make sure that there have been no hits. I can think of a case that we have right now that's an old case, that there was no CODIS hit. And right now, we don't have a case on file, so we don't have the ability to request discovery on that case. If we filed for a DNA motion and received a DNA order, I think we could request it at that point in time, but maybe strengthening the language that allows defense counsel to go back in periodically and ask the prosecutor or the county attorney, hey, can you check the LIMS system and see if there's been a hit on this case? And so just that sort of back end aspect of it, at least for defense counsel, maybe needs a little bit of work before we submit in December.
Okay, Tricia, did you have anything you wanted to add?
Yeah, I echo everyone's thanks and for all of this work. I know there's a lot of folks that go into this. I think very similar to what Alice is saying. I think for me, where I struggle a little bit is this was just so illuminating, because it looks like the access is all through LIMS. We might train people to log into it to look, but that's really not a guarantee that someone is looking. And so I just have real concerns about, you may be trained to know, but like I know my calendar, and I imagine y'all's calendars look very much like mine, where if it's not in there that I have to look or I have to do it, it's very easy, I think, for it to fall through the cracks where, you're working on your active trial, you're doing all these things, so very understandably, someone wouldn't go in and look at it. So I do just wonder if there's a way to make sure there's periodically someone has to look at it, because you just wouldn't be thinking, if that's the only way to get notification, I just don't want it to fall through the cracks.
If I could, to Tricia's point, there's still a report that's generated that would automatically go to local law enforcement. The ability of the prosecutor to look is a proactive one that we could be searching the database. I'd hate to think, you're right. I don't think we're going to be sitting there daily looking at all of our cases, but if there was a request or if there was any concern, that would certainly be something we could do proactively. But the report is still being generated and still being transmitted to law enforcement. And in certain cases, it would actually be generated to go to the prosecutor directly. I won't say that's every case, and it's probably not the majority of cases, but there are some, and Robert can correct me or Jeff can correct me if I'm wrong, but there are some where it would go directly to the prosecutor.
I appreciate that, and I think it's helpful for me to help try to understand it, because then I think what I'm hearing is, even if the report goes to law enforcement, these guidelines don't have a requirement then for law enforcement to let someone know, right? We've really put in that the prosecutors are the folks that are being trained on the Brady violation, the continuing duty of Brady to disclose and to go into LIMS and look. So I just think there might be still a little bit of a connection we might need to be making to link things through all the way.
What about those of you who were not on this little working group? Any thoughts or questions at this point? And I realize you've not had a whole lot of time to digest this, so we're not going to be making any official decisions today by any means. We're certainly going to have a meeting again sometime in the near future and continue to tweak this a little bit. But while we're all here, are there things that you'd like to add? And I can't see you, so just start speaking, and I hope you don't all speak at the same time.
Hi, this is Sheriff Hill with Shawnee County Sheriff's Office. Prior to becoming sheriff, I was a major case homicide detective in the city of Topeka, and I oftentimes, or not often, but several times did get CODIS hits and had some experience with this. And most of the cases we had, the notification did go to the district attorney as well, because they were homicide cases actively filed. But yeah, it seems to be notification has always kind of been the issue for law enforcement as well. because there were some cases at times that seems to be a delay in getting those notifications or getting advised of CODIS hits.
Very good. Corey, were you about to speak?
Yes, I was. Thank you, Chairman. I echo Trish's comments. I agree that I appreciate the report and the requirements or the suggestions for additional training. I think that's a great first step. But I wonder if we can do more things to tighten the language and add more teeth to actually having requirements to make sure that process is followed through outside of just training.
Anyone else out there? Comments?
Mr. Chairman, Representative Carmichael.
Good to see you, sir.
Nice to see you, boss. It's been a while. I agree with Mr. Sheedy. I mean, I recognize that everyone has the best of intentions, but we need to find a way to impose affirmative requirements so that there is a bright line as to what is required of prosecutors and law enforcement. And quite frankly, should there be information that is not provided for whatever reason, there needs to be a bright line that judges can look at to determine whether or not a defendant's rights have been violated. And so I hope that we can come up with something that is pretty specific about what thou shalt do.
Anyone else?
Mr. Chair?
Yes.
Okay, this is Haley again, and I appreciate these comments. We want to get it right. You know, we certainly want to respect the privacy concerns and the procedural ones that CODIS would put in place, and I certainly am anxious for us to do that as well. I hope we're not trying to completely reinvent a procedure here, reinvent the wheel. I've asked that we look at some of the celebrated cases that have come in already, and actually have asked a few people, visited with a few people from within the legislative staff to look at some of these successes, if you will, in the use of DNA in the resolution of some cold cases. And we could certainly at some point review those, find that they're not violative of the chain of custody for various technologies, or if they are, tweak them, if you will, as to how it would maintain those, and certainly use them or add them, I hope, to our considerations. Those cases have shown how crucial it is that we do get it right, and that we do have access to that which we can, and that we can draw from the technology. And I would hope that we can make that a part of our consideration for the task force consideration, if that could be disseminated.
Absolutely. Natalie Nelson sent me an email earlier this afternoon and said you'd requested that. And so however we can get that before the committee will certainly, or task force, certainly get that done.
Thank you, sir.
Other thoughts at this point?
Mr. Chairman, Carmichael again. I don't know if this is the appropriate time to raise the issue, but when I was looking at the legislative website, we don't have any legislative members listed for this task force. And sometimes that happens because the minority leader or majority leader or speaker or someone has not notified the clerk of the House or legislative services or somebody. And sometimes that could even keep, heaven forbid, us from getting paid. I wonder if anyone could some member of the staff could make some inquiry for us and see who the legislative members are and make sure we get it on the website. And yes, make sure we get paid. Thank you.
I do know that the LCC has approved us meeting. That may help in that process. And yeah, I'll make a note that we look in that. The legislative members are by statute the chair of both committees and of House and Senate Judiciary and the ranking member. So Warren, Carmichael, Haley, and myself. But it would be nice that it shows up on the website so people, when they click on your name, they know to send you emails.
And I always appreciate that. Thank you, Mr. Chair.
Okay, if there are not other thoughts on the recommendations at this point in time, certainly we've got a couple issues that it sounds like we should continue to tweak and work on. We're also under a deadline, so we don't have a whole lot of time to come up, at least with our recommendations that we're going to put in the report. My thoughts are, which you are all certainly welcome to disagree with because you know more about this than I do, but should we have that 4-member group or anyone else that's willing to kind of work together, less than a quorum, so we don't run into any Open Meetings Act, continue to tweak a report that could be presented to us, and maybe you won't come to agreement. I mean, we were fortunate at this point in time that it looked like we had the prosecutors and the advocates kind of made these recommendations. Maybe we can't get there, and that's fine. That would be up for the task force to, at our next meeting, discuss and vote and determine which ones we want to move forward as a task force. But anyone else want to play a part in this? Tricia and Professor Craig, are you willing to kind of help those that have, Darren and Justin, Jeff, and whoever else, kind of come up with something that we could have, maybe that 3rd week of September? That doesn't give you a whole lot of time to meet and come up with something, but then that would give us a time to set up a meeting that we could then try to meet that October 1st deadline. If not, I hear they send Representative Carmichael to jail, so we don't want that to happen.
We'll represent him.
3 hops and a cot, Mr. Chair. 3 hops and a cot.
I'll give you my card. You can just call me. I think Tricia and I would be happy to help.
Anyone else? Again, we got to keep the numbers fairly small, that wants to be a part of that. And maybe back to Senator Haley's request, if we get that information, if Natalie or Robert or whoever's compiling that, if there's something that they could send out in advance to us so we could kind of review some of that, certainly discuss it at the next meeting, but that way it's not a last minute presentation and we're asked to vote at the next meeting on finalizing a plan. It'd be good to have whatever Representative Haley has been working on in advance.
Senator Haley, I think you were just demoted to representative by
oh gosh, sorry about that.
Chair there.
So, so you asked, we've all been there, haven't we, Madam Co-Chair?
Yes.
We've all been there. Some of the finest days of my life.
Mr. Chairman, that is not a demotion.
Yes.
As a matter of fact, that's an accolade of great legislative ability, and I wish you were in the House, David.
So many people actually they prefer.
Okay, so is anyone disagreeing with me? Again, I'm open to other ideas, but I'm not seeing hands go up or heads shaking opposite directions of the way I want you to shake your head. So Chairman Warren, I know you're new to this task force and we're kind of throwing you in at the last minute. Certainly any direction, if you'd like us to go a different route, I'm open to that as well.
I think the task force is well directed and looking forward to seeing what kind of the subcommittee of the task force comes back with. And yeah, in advance of the next meeting would be great, just so we could consider it a little bit further and more in depth as we get closer to issuing the report. I think it's good to make to take a look at a balance between both sides. That's what we try to do in government, and to proceed that way is a good idea. So I thank those that are kind of on the subcommittee there working together to do that.
Perfect, very good. Okay, well then that's what we will do. We'll have you guys get back to work and try to tweak the proposal a little bit. And again, if you can't, I understand that, but come each ready to argue your position, and as a task force, we'll try to hammer out what we agree with. We'll have Natalie Nelson again kind of touch base with everybody, and we'll try to find that next meeting time for the full task force. And if that's all I have. It's only 2:35. You guys have time to get caught up on other things because we got done early. But I do appreciate everyone's work, and I apologize that we didn't get this done last year. But as you know, lots of things didn't get done last year, and now we'll just have to make sure we meet these deadlines because as many of you have raised, certainly this is an area that we need to do a little work on, and I'm glad already things are improving just because we had the task force and you guys were able to sit down and visit and start doing some training. So things are moving in the right direction. We just need to keep moving them that way. If there's nothing else, thank you all. We will be in touch with the next meeting and that subcommittee or whatever we want to call you guys. If you need anything from me, let me know. You can certainly email, call whenever, and we will be in touch really soon with the next meeting date. Thank you all.